Bankruptcy is often seen as a last resort, but for some individuals, it can also offer a critical second chance. Understanding what bankruptcy is, how it works, and how it varies across the U.S. is essential for making informed financial decisions. In this module, we'll explore the main types of bankruptcy available to individuals, the legal process behind them, their impact, and what to consider before filing. What is bankruptcy? Bankruptcy is a legal process, overseen by federal courts, that allows individuals or businesses to eliminate or restructure debts they cannot afford to repay. The purpose of bankruptcy is to give honest debtors a fresh start while ensuring fair treatment of creditors. Types of personal bankruptcy. There are two main types of bankruptcy available to consumers. Chapter 7, Liquidation Bankruptcy. Most unsecured debts, like credit cards and medical bills, are discharged. You may have to sell non-exempt assets to repay creditors. Usually completed in about 4 to 6 months. Stays on your credit report for 10 years. To qualify for Chapter 7, you must pass a means test that compares your income to your state's median. Chapter 13, Reorganization Bankruptcy. You keep your assets but must follow a court-approved repayment plan. Payments are made over 3 to 5 years, based on your income and debt. At the end of the plan, remaining eligible debts may be discharged. Stays on your credit report for 7 years. Chapter 13 is often used to stop foreclosure, catch up on missed payments, or restructure debts when Chapter 7 isn't an option. State-specific exemptions. Important, while bankruptcy is governed by federal law, each state sets its own rules about what property you can keep. These are called bankruptcy exemptions and may include things like your home, car, retirement savings, and personal belongings. Some states let you choose between federal and state exemptions, but you can't mix them. Always check your state's specific exemption rules before filing. The bankruptcy process. Here's what to expect if you file for bankruptcy. Credit counseling. You must complete a government-approved credit counseling course within 180 days before filing. Filing petition. You or your attorney will file a bankruptcy petition with the court. Automatic stay. This court order immediately stops most collection actions, including wage garnishments, lawsuits, and calls. 341 meeting, also called the meeting of creditors, where you answer questions under oath. Resolution. Depending on the chapter, your case will either result in debt discharge or a repayment plan. The entire process is handled through the U.S. bankruptcy court system and may take several months to several years, depending on the chapter. Who should consider bankruptcy? Bankruptcy may be a reasonable option if you have unsecured debts you cannot repay, are facing foreclosure, wage garnishment, or lawsuits, are using credit cards to cover basic expenses, have no feasible way to repay your debts within the next 3 to 5 years. But it's not right for everyone. Bankruptcy should always be approached with full awareness of the consequences. Credit and financial impact. Bankruptcy will affect your credit. A Chapter 7 bankruptcy stays on your credit report for 10 years. A Chapter 13 bankruptcy stays for 7 years. You may have difficulty getting loans, credit cards, or housing in the near term. Interest rates on new credit may be much higher. That said, many people begin rebuilding credit within 1 to 2 years of discharge with proper planning and responsible behavior. Legal and professional guidance. Bankruptcy is a legal process, and it's strongly recommended to work with a bankruptcy attorney. They can help you determine eligibility, protect your assets, prepare and file legal documents, navigate court proceedings, avoid costly mistakes. Filing bankruptcy on your own, also known as Pro Se, is allowed, but it is rarely advisable due to the legal complexity. What bankruptcy can and cannot do. Bankruptcy can eliminate most unsecured debts, credit cards, medical bills, personal loans, stop collection activity and lawsuits, delay or stop foreclosure or repossession, provide breathing room to reorganize finances. Bankruptcy cannot eliminate most student loans unless undue hardship is proven, erase child support or alimony obligations, remove most tax debts, discharge debts from fraud or criminal fines. Always review your full list of debts with a legal professional to know what will and won't be discharged. Alternatives to bankruptcy. Before filing, you should consider alternatives like debt negotiation or settlement, credit counseling or debt management plans, budgeting and expense reduction, selling non-essential assets. Bankruptcy is a serious decision. Explore other options first, but don't delay too long if you're facing legal action or mounting penalties. Bankruptcy is a powerful legal tool that can eliminate or restructure debt and help you start over financially. But it comes with long-term credit impact, public record status, and strict legal processes. It's not for everyone, and it's not a decision to be taken lightly. But when used wisely, and with legal guidance, it can be the first step toward long-term financial recovery. Before deciding to file for bankruptcy, speak with a qualified bankruptcy attorney. Review your state-specific exemptions and rules. Understand which debts can and cannot be discharged. Consider alternatives and compare long-term impacts. Need help finding a certified bankruptcy professional in your area? Our team can connect you with licensed legal experts who understand the laws in your state.